Hello, everybody. This is Steve Yoder. Welcome to week 6 in Legal Studies 457 557 here in the spring of 2024 at the UAB Collat School of Business. Last week's extra credit opportunity was a question about what Joe Biden said in his State of the Union address about the corporate income tax rate. He has asked that the nominal rate be increased from its current rate to 28%, but that there be a corporate minimum percentage of 21%. Currently, that corporate alternative minimum tax is 15%. And those of you who have studied corporate or even individual income tax know that there's a difference between what a tax bracket is and then what a minimum tax percentage is. The nominal rate is what you'll pay if you have no deductions or credits, but it is possible to have a lot of deductions and credits. And in the corporate side, you could end up having so many credits that the minimum comes into play, and the minimum is 15, but the minimum would be 21%. But if you did not have that many credits or deductions, the corporate rate will, under Biden's plan, go to 28%. I think it's highly unlikely we'll see that before the next election. Second exam is closed. I'll be coming out with results on that on Monday the 15th. Agency law underpins a number of parts of our lives. It's the most common legal relationship that there is, but particularly employment law, which we are looking at this week. A great deal of content to cover. Employers have two types of workers, those who are officially employees and those who are independent contractors. There's a big difference there, including in whether the worker gets to split the cost of their Social Security, FICA insurance, or do they, FICA benefit, I should say, or do they have to pay it all themselves? FedEx says they're not employees, they're independent contractors, they're workers, and those workers have to pay 100% of their FICA cost. UPS says no, they're employees, we'll split it with you. This has been very much in the news in California. California passed a law several years ago that said Lyft and Uber drivers, similar types of positions, are employees and should get treated like employees, including for purposes of FICA. California voters put a proposition, which they can do in that state, on the ballot, which reversed that. And let's suffice it to say it's still tied up in the court system. The increase in protection of workers in our country, really most countries around the world, began in the early part of the 20th century. This is an early poster from that time. Many people trace it to the terrible fire that occurred in a factory, the Triangle Shirtwaist Factory in 1911, when many people died because among other things, the fire doors were bolted shut. Employment at will, many people would point to as the basic principle of having a job in America, which is to say that you can be fired at any time. The reality is that that's really not the case. Many laws, starting in the early part of the 20th century, have begun to chip away at that and protect us in various ways, including whether we can be fired. But the first laws that protected employees were wage and hour laws that provided for overtime rights. There's a case in your book about whether or not service advisors at car dealerships are entitled to overtime. President Obama felt strongly that the threshold below which in annual pay a worker should automatically be entitled to overtime. At the time that President Obama was concerned about this, the amount was 35,568. He wanted to raise it to 47,000. Businesses sued and said that for various reasons that should not happen and blocked that from taking place. President Trump then came into office and agreed with that result. President Biden, pretty quickly after getting into office, said, well, inflation has taken over, and I think the minimum should be 55,000, and suffice it to say that business groups oppose that. I think it's pretty clear that no matter what the amount is, no matter what the threshold is below which you get overtime, many businesses are going to pay as many people as they can, at least that amount, so that they don't have to pay overtime. Uh, uh, Take a look at this video so you can answer this question. This is fair game for a question on the next exam. Can an employer simply ask an employee to waive his or her right to overtime? The minimum wage is also something covered by the Fair Labor Standards Act. There's been a lot of upward movement in minimum wages. This is the map showing that just in 1 year the increase is occurring in the United States in the minimum wage. The labor shortage has caused pushback on one of the other main features of the Fair Labor Standards Act, and that is prohibitions on child labor. McDonald's franchisee, you can see here, I think this was in Pennsylvania, had to pay a fine for not following the rules for employing 14 and 15-year-olds. Some states have actually loosened the laws in those states about child labor, including Arkansas. And you can see the date on this article is February 21, 2024. So this is very much in the news. The Family Medical Leave Act is perhaps you could say one of the bookends at the later end of the book of improving workers' working conditions. The FMLA requires larger employees to provide 12 weeks of unpaid leave to employees to take care of themselves or certain other people. It should be noted that the U.S. is behind many countries in making this leave unpaid. We have a series of laws that were passed between about the 1930s and later that protect our income at various stages of our lives, whether it's an expected stage, such as retirement, or an unexpected stage, such as disability. The Social Security Act, as I said earlier, is one of the key battlegrounds over whether someone's an independent contractor or an employee. The Affordable Care Act, a recent protection of not just employees but all people, is something that the CPA examiners believe that all CPAs need to know about. And starting in 2024, the CPA exam will include questions on the ACA. And take a look at these bullet points in the blue box here, particularly the first one. At least one of those is probably going to appear in your CPA exam that covers business law and is definitely going to appear in the pool of questions for the third exam. Here are some other features of the Affordable Care Act. Stop, pause, make sure you look at this. You all probably are familiar with the requirement for a 1095-C. Immigration law is broken in the United States. Demographics around the world, economic conditions around the world have changed greatly in the last 40, 50 years since the immigration laws were written, and they need to be revised. Just leave it at that for right now. Labor relations, whether employees can create a union, is very cyclical in our country. We go from periods of time where the laws try to help unions, and then we go through periods of time where the laws seem to be going in the other direction. I want everyone to know what a closed shop is. Take a look at that both in the textbook and in the slides. We've seen a trend recently toward more efforts to get unions. Alabama is an example. Union votes have so far failed at Amazon, but they seem to be winning recently, not quite there yet, at the Vance Mercedes-Benz plant. Starbucks, another hotbed of union organizing activity. The law provides that retaliating against workers who are trying to form a union is against the law. They're called unfair labor practices, and there are a great many allegations against Starbucks that they're committing unfair labor practices by, for example, firing a worker who is leading the charge to create a union. Again, these are very recent news stories that you're seeing here, February 2024. Georgia has passed a law to make it harder to create a union. Unions would like to organize and get approval for a union in a particular location simply by passing around cards and having people at lunch check yes or no on the card. The Georgia legislature, but not yet signed by the governor, has passed a law that says that a card check is not enough, that there actually has to be a formal vote taken. And their effort is to make it harder to do to create a union in a particular place. Interestingly, the hook that they're using is that if any company, like say Hyundai, were to allow a union to get formed simply by using cards passed around at lunch, all economic incentives from the state would be taken away. Employment discrimination, a huge topic since the Civil Rights Act of 1964 was passed. Look at the categories that are of traits and characteristics of a human being that you may not discriminate on the basis of race, sex, color, religion, and national origin. Those are called protected classes. Uh, Race and color are not the same thing. Both of them are protected classes. Religion is a protected class. Employers have to reasonably accommodate someone who has a sincerely held religious practice. Does not have to be one of the mainstream religions. Gender discrimination can take two forms. Gender is a protected class, either treating somebody different in the workplace based on their gender or harassing someone based on their gender. Non-compete agreements that we've talked about in an earlier class disproportionately hurt women, research has found. Sexual harassment is against the law. These are myths. Look at these and don't do them. Look, these are in the PowerPoint slides. Myth. Don't test these things. Age came along later as a protected class, and you may not discriminate against someone on the basis of their age. Look at the case example in the textbook 29.14, where the allegation against a supervisor at a bank was that the supervisor had said something once, maybe twice: we old dogs have to learn new tricks. You say something like that, you're going to get a lawsuit based on age. Disability is a protected class, and there the law manifests itself by requiring that employers offer reasonable accommodations for those who have disabilities. Affirmative action, very much in the news. It is a violation of the Equal Protection Act, has been for over 40 years, to favor someone in a protected class simply to make up for past discrimination against that protected class. However, until recently, it was permissible to have affirmative action programs, particularly in colleges and universities, where the basis was that you get a better education if it's a diverse environment. Here is your extra credit opportunity for this week for 2 points added to the last exam. Tell me which two universities' admissions policies were found by the U.S. Supreme Court in 2023 to violate the U.S. Constitution because they gave special treatment of some kind to people in protected classes. And finally, here is our calendar. Today is income tax filing date, April 15th. Look what's coming up next week. Reflective memos due on the 22nd. Last set of CPA client consultations due on the 24th. And then the third exam and a number of other items will close and will be due at 11:59 p.m. on the last day of the semester, Friday, April 26th.